prosecutor smirked, waving her off like a stray from the sidewalk. But when the witness pulled a signed contract from the state attorney's office, the courtroom's air shifted, fast. What happened next left even the judge speechless. I wasn't supposed to be there, at least not according to the prosecutor in a navy pinstripe suit who didn't even look up when I stepped into the courtroom. She barely flicked her wrist to gesture at the bailiff, muttering something about unauthorized access. To them, I was a ghost, a civilian with no right to breathe the same air, let alone sit near the witness stand. But I had a signed contract, not just any piece of paper, a state-issued agreement, sealed with the cold, crisp signature of the state attorney himself. And that piece of paper, folded precisely in thirds, tucked into my inner blazer pocket, was about to become the first domino to fall. The courtroom buzzed with low voices and chair shuffles, like a hive unsettled. Fluorescent lights cast pale glows on weary faces, and the air smelled faintly of old paper and burnt coffee. I walked down the center aisle, heels tapping too confidently for someone not on the list. I saw her then, the prosecutor, raise her chin. "You're not on the witness list," she said, eyebrows arched, tone clipped like a blade. My fingers moved with practiced calm. I pulled the folded contract from my jacket and handed it to the bailiff. The room stilled. She glanced down, scoffed, until her gaze locked on the header. Office of the State Attorney, Direct Contractual Authorization for Testimony. Below it, bold black letters stamped with urgency. U.S. Code, paragraph 3502. The bailiff blinked. The prosecutor's smirk vanished. She whispered something to a paralegal who scurried off toward the judge's chambers like a scared rabbit. Exactly as I expected. 18 minutes passed. In silence, I sat, perfectly still, while the courtroom held its breath around me. No one approached, no one dared. The clock ticked like a countdown. Then the door creaked open. A federal marshal entered, black suit, tight jaw. He leaned down to the judge, whispered just loud enough for the first few rows to catch fragments. Order from the U.S. Attorney. Interrogation is suspended until further review. Suspended. The word hit like a lightning strike through dry air. Papers rustled, chairs shifted. The prosecutor stiffened as though she'd been slapped. Proceed, the marshal added. She's admitted. And just like that, I became the most important person in the room. Not because I shouted, because I planned, because they underestimated the quiet woman with the sealed envelope, because the court doesn't care who speaks loudest. It cares who has the right paper, the right clause, the right line of ink from the right pen. And mine came from the top. They didn't see it coming. Not the judge, not the prosecutor, not even the courtroom staff who thought I was someone's assistant. But I'd spent 5 months preparing for this moment, tracking signatures, reading court memos at midnight, staring down closed doors until one opened just wide enough to slip a truth through. And now the truth had a microphone. They thought I'd break. They forgot I'd already been broken and rebuilt sharper. I didn't blink when I stepped up to the witness stand. There's a certain silence in a courtroom that doesn't feel like peace. It feels like waiting to be ambushed. The prosecutor adjusted her collar, clearly rattled, but trying hard to wear confidence like perfume. It didn't stick. Her previous smirk had melted into something taut and uncertain. I placed my hand on the Bible, swore in. My voice didn't shake, not because I wasn't nervous, but because I'd already rehearsed every breath, every glance, every single word. 5 rows back, someone was typing fast on a laptop. Likely the court clerk logging the suspension notice, issued not 5 minutes ago via official U.S. Attorney court order. A clear signal. I was no longer optional. I was the main thread. "Ms. Rivas," the judge began, using my last name like it had weight. You're here under direct authority from the state attorney's office. Is that correct? Yes, Your Honor, under Contract Section 4B, subsection 6. I turned slightly and met the prosecutor's eyes. Signed, certified, delivered. A few in the gallery shifted. One man, defense probably, raised an eyebrow. Another leaned in. She tried to object. Of course she did. We were never notified of this witness. There's no indication she was vetted, no digital filing on the pretrial motion. This is highly irregular. The judge's gavel dropped once, sharp, clean. Ms. Rivas is protected under Federal Disclosure Code. She's on the record. Continue. And there it was, the exact phrase I needed. On the record. I opened the file in front of me, neatly tabbed pages, yellow post-its like breadcrumbs. I laid out a printed email thread dated 4 months prior. Subject line, witness list modification, urgent, confirmed by state legal. It was addressed to the same prosecutor now squirming in her ergonomic chair. She'd seen this. She'd ignored it. Now she'd pay for pretending not to. My voice held steady as I read, "Please confirm acknowledgement of the witness list update. Per state legal instruction, this witness is protected under Clause 7A until trial testimony. Do not disclose. Signature, J. Heller, State Attorney." The courtroom wasn't just silent now. It was electric. She knew. And she had gambled that I wouldn't show. That I wouldn't know the weight of my own presence. That I wouldn't dare use her own ignored emails against her, in front of her peers, the judge, and 6 courtroom recorders. But I came armed, with receipts and signatures. She tried again, her voice a notch higher. This doesn't establish relevancy. I didn't answer her. I turned to the judge. I have records, Your Honor, from inside their department, including deleted drafts, internal memos, and withheld Excel spreadsheets containing names, timestamps, and IP logs. Every single entry has metadata intact. The judge nodded. Enter into evidence. Behind me, I heard one of the defense attorneys whistle, low, involuntary. I locked eyes with her. This wasn't just about showing up. It was about staying. It was about proving that some women don't need to scream to bring a system to its knees. Just a courtroom, a contract, and the audacity to come prepared. They thought I was just a name they could erase from the witness list. But I brought the ink they used to sign it in the first place. Power doesn't always knock. Sometimes it walks in, uninvited, and stays. Let me know in the comments if you're still with her. She just rewrote the rules. You in? They thought it was over when I stepped down. But stepping down wasn't surrender. It was strategy. The prosecutor avoided my eyes, fumbling with her pen like it might suddenly rewrite the facts. The judge recessed the hearing for 15 minutes, and as the courtroom slowly emptied, I stayed seated. Not out of defiance, out of intention. I needed her to see that I wasn't going anywhere. My contract with the state attorney had been clear. Temporary classification until court appearance, immunity from internal retaliation, full access to redacted files through secure login. What it hadn't detailed, at least not in writing, was what I'd risked to get that contract signed in the first place. Because truth? They didn't come to me. I went to them. 3 months ago, I stood outside the downtown municipal office at 6:47 a.m., clutching a manila envelope full of evidence that would make a courtroom sweat. I waited until the third-floor lights blinked on. I knew exactly which one was his. J. Heller, the state attorney. Sharp suits, sharp mind, sharper boundaries. But boundaries mean nothing when someone walks in with a list of deleted names from an official witness registry, and metadata proving the deletion came from inside the prosecution's office. He didn't want to believe me, until I showed him the login ID tied to the edit. Her login ID. the same prosecutor now pretending to scribble on a legal pad while her entire case sat on a foundation that I just cracked wide open. The 15-minute recess became 23. When the judge returned, so did the press, drawn in by the phrase witness list manipulation, like blood in the water. Local news, 2 bloggers, even someone from the city's legal ethics board, whispering into a Bluetooth headset with concern creasing his forehead. "Ms. Rivas," the judge said, "please remain available for a second session. We'll reconvene in 1 hour for document admission." I nodded once. The prosecutor flinched, but she wasn't done fighting. Just as I was gathering my things, she rose and addressed the bench, voice steady, but with that forced professionalism people wear like armor when they're losing ground. "Your Honor, I move to suppress the spreadsheet evidence submitted in Exhibit C. It contains unverified data." I didn't wait for the judge's response. I turned. "I have the original server logs, authenticated by a digital timestamp and verified through a chain of custody. Would you like those entered as Exhibit D?" She paled. The judge raised an eyebrow. "Submit." And just like that, another door locked behind her, because it wasn't just a spreadsheet. It was a map of what she erased, of who she silenced, and now it was public record. The marshal handed my badge back as I stepped out into the courthouse lobby, fluorescent lights giving way to dusk-streaked windows and murmurs of new voices. Somewhere behind me, her reputation was already starting to burn, not in a scandal, not in a headline, but in a slow, documented collapse, one entry at a time. Don't mistake silence for absence. Some of us don't knock because we already have the key. The courthouse lobby always felt colder in the late afternoon, like the walls absorbed every lie spoken between them and reflected it back as air conditioning. I stood near the vending machines, badge still warm in my hand, watching the prosecutor through the glass as she argued in hushed tones with her paralegal. She kept glancing toward the hallway, probably hoping I'd disappear. I didn't. Instead, I stepped back toward the elevators, not to leave, to wait. In exactly 16 minutes, the next session would begin. The judge had made it clear: document admission, full witness transcript review, and cross-reference with the digital logs from the state's records archive. Translation: time was no longer her ally. But this wasn't just about evidence anymore. This was about why she tried to bury me in the first place. 3 months ago, before contracts and courtrooms, I was just a consultant, brought in quietly to audit inconsistencies between deposition testimonies and filed reports. It was boring work until I found a name. Mine, on a version of the witness list, then removed 2 days later. No explanation, no update, just erased. And here's the thing. I never volunteered to testify. I didn't raise my hand. Someone put me there, and someone else decided I was too dangerous to stay. That's when I understood. They weren't afraid of my voice. They were afraid of what I knew. The next file I reviewed showed 2 more names with the same pattern: added, time-stamped, deleted within 48 hours. One was a translator from the legal intake department. The other, a temp who worked 3 nights of file digitization in the evidence annex. Neither worked there anymore. I called the translator. Her line was disconnected. The temp? Moved to another city, no forwarding number. That's when I started printing everything: courtroom security logs, witness list version history, logged access to digital records from internal IPs, even the signature history of the state attorney's office contract templates. Not to leak, not to threaten, just to be ready. Because the truth is, I didn't want revenge. I wanted insurance. Insurance that if they tried to silence me again, I wouldn't have to shout. I'd only have to show up. And now, here I was, holding a keycard authorized by the state attorney, a signed clause stating that denial of entry to court would constitute breach of contract, and a USB containing verified, immutable server logs. The prosecutor still hadn't seen the worst of it, because Exhibit E was still in my purse, untouched, not a file, a recording, one sent to me anonymously, one that proved who ordered the names deleted. And when that moment came, it wouldn't be loud, it would be legal, it would be clean, and it would be irrevocable. She tried to erase me, but I came back with receipts. Some stories don't end with the signature. They start with one. The moment I walked back into the courtroom, I knew the power had shifted. You could feel it in the way the reporters stopped whispering, in how the judge subtly leaned forward, in the way the prosecutor's pen stilled mid-sentence as I re-entered. I didn't sit right away. I approached the bench with calm precision and offered the flash drive to the court clerk. "Exhibit E," I said clearly. "Private submission, time-stamped, audio verified." The judge looked at me. "Is this in relation to the previous witness list deletions?" "Yes, Your Honor. It contains a direct verbal confirmation from a department-level official authorizing tampering." I heard the click as the prosecutor's pen finally dropped. She stood up so fast her chair groaned. "Objection! No proof of authenticity. The source of this file is unverified and inadmissible." The judge cut her off with a slow, deliberate motion of his hand. "I'll determine that. Sit." She did, but not gracefully. Her jaw was clenched so tightly I could see the muscle twitch beneath her cheek. The recording began to play. The room stiffened. "You don't get it. She can't testify. She was a third-party contractor. Delete her name. No one will notice. Do it from your login. Make it disappear." Silence followed. The judge tapped his gavel once, then twice. "Pause playback. Ms. Rivas, do you have corroborating metadata?" "I do. A copy of the audio file was submitted to the Office of the U.S. Attorney 10 days ago. This copy was authorized for court under Clause 3B of my contract." I could feel her staring at me. The prosecutor. Burning. Reeling. She thought this was about taking her down, but it never was. This was about making sure no one else got erased because it was convenient, because they were temporary, because they didn't have the right title under their email signature. I was done watching silent people get folded out of the truth. The judge turned to the clerk. "Please file an ethics inquiry notice with the Legal Oversight Board, immediate review, and notify the U.S. Attorney that further investigation into internal suppression is now court-mandated." My work here was nearly done, but not yet, because I still had one more contract. Yes, another. A separate clause signed by the U.S. Attorney himself, buried in the fine print of my cooperation agreement. Clause 9C, in the event of institutional obstruction or evidence suppression, witness may submit to federal oversight bypassing local jurisdiction. That clause gave me the final word, and the next step. They thought the witness list was a gate. I made it a door. The hall outside the courtroom buzzed like a disturbed hive. Reporters hovered near the vending machines, flinging questions like darts. I ignored them. My focus wasn't on headlines. It was on follow-through. I headed straight to the Legal Records Division, badge still clipped to my lapel, contract still in my jacket, and in my hand, a printed copy of Clause 9C, now circled in red ink. The clerk at the records desk blinked as I handed it over. "You're filing for federal bypass?" he asked, like I'd just declared war. "No," I said calmly. "I'm filing for transparency." Because in the fine print, the clause didn't just grant me protection, it gave me access, immediate, unrestricted access to sealed internal files related to the case, including personnel memos, disciplinary records, and email chains marked confidential. He hesitated. "This usually takes weeks." I slid over a second page. the court transcript from 30 minutes earlier, now stamped with the suspension notice issued by the judge himself. He exhaled. "Give me 20 minutes." I nodded. When I returned, he handed me a sealed envelope. Inside, 6 printed pages, a flash drive, and a handwritten note from someone inside the agency. "I've been waiting for someone to request this. Good luck." Page 1, a disciplinary warning issued to the prosecutor last year for similar behavior. Page 2, an internal memo outlining acceptable adjustments to witness lists in cases involving reputational risk. Page 3, a digital footprint map, IP addresses, file edits, unauthorized deletions. Page 4, an email chain in which she requested access to the sealed witness list 3 days before I was removed, with no reason cited. Pages 5 and 6, redacted. But the headers said enough. Informal communications between prosecution and state-affiliated private counsel. I knew what that meant. It wasn't just her. She wasn't alone. And this was deeper than one erased name. It was a system, trained to erase, polished to deny, skilled in plausible deniability. But now, with my contract, my evidence, and now, my federal clause, I had something they hadn't counted on. I had proof of pattern. And when patterns become evidence, people stop being individuals. They become part of a chain that, if pulled hard enough, rattles the entire foundation. They taught me the rules thinking I'd follow them. I read them so I could use them, against them. The hearing resumed the next day. Same courtroom, but the atmosphere had mutated, like the air itself had learned to listen more carefully. This time, I didn't take the witness stand. I took the attorney's table. Contract Clause 12G allowed for it. In the event of obstructive conduct by institutional officers, the protected party may assume co-counsel privileges for evidentiary support. Unusual? Absolutely. Illegal? Not even close. I wasn't here to grandstand. I was here to make sure nothing disappeared. Again. The prosecutor walked in 5 minutes late. Hair tighter, suit darker, smile nowhere to be found. She didn't look at me. Didn't need to. Everyone else already was. The clerk began reading the newly submitted exhibits aloud. One by one, each page I'd retrieved from the Legal Records Division became part of the public record. The disciplinary memo, the deleted witness logs, the email chain with no legal basis, even the redacted communications, which the judge had ordered unsealed after reviewing Clause 9C. And when that happened, she cracked, just a little. Her voice rose just a notch when she objected to the admissibility of the sealed memo. Her hands fidgeted when the judge asked about the deletion timestamp, and then came the line that changed everything. "Your Honor, I was following internal recommendations. I didn't act alone." Those words froze the room. Even the judge blinked. "Would you like to name who authorized those recommendations?" he asked. Her lips parted, then pressed shut again. The silence said enough, because if she did, she'd take down someone above her, and if she didn't, she'd go down alone. Either way, the ceiling above her just started to sweat. The judge recessed for the day. Proceedings will continue pending federal ethics review. I gathered my notes, slid them into my bag, and stood. As I walked past her, she finally looked at me. Not with anger, with recognition. Because now she understood. This wasn't personal. This was structural. She hadn't erased me. She'd spotlighted herself. You can't redact what's already been read out loud, and you can't silence someone who signed their name in ink, backed by law. It was never about winning. Not in the way people usually define it. No gavel slam, no standing ovation, no dramatic headlines with my name in bold. Victory, in cases like this, arrives like a paper cut, subtle, sharp, and undeniably present. The Federal Oversight Board scheduled a review hearing in less than 48 hours. That alone said everything. Normally, these things crawled through layers of red tape and procedural maybes. But my file, thick, indexed, triple-backed with source logs and contractual authority, had passed directly to the top of their priority list. I wasn't surprised, because when you show them the strings, they start asking who's holding them. Back in my apartment that night, I laid everything out on my kitchen table. A war room in the shape of laminate wood and takeout containers. Each document, each email printout, each flash drive sat in its place like soldiers on a silent battlefield. And at the center, the witness list. 5 names, mine included. 3 were officially removed. 2 had been pressured into silence, a clerk who never spoke up, and a temp who resigned. But not me, because I had a weapon no one expected. Patience. They always assume that the ones who stay quiet are weak. They forget that quiet is just the sound before thunder. The next morning, I met with a junior U.S. attorney assigned to investigate the case. Fresh pressed shirt, eyes too sharp for his age, notebook open before I even sat down. "You realize," he said, "what you uncovered wasn't just misconduct, it's systemic." I nodded. "That's why I documented everything." He leaned in, almost reverently. "And you kept receipts for all of it." He let out a breath. "Then we'll be pursuing obstruction, evidence tampering, and potentially, if confirmed, a coordinated suppression of federal witness identities." I didn't smile. I just handed him one last folder. Inside, screenshots of an internal Slack conversation, joking about how low-level witnesses are easy to lose in Excel. And there it was, the crack that split the floor beneath them. Jokes turn into evidence faster than anyone realizes. Because when you hide behind systems, behind spreadsheets, behind procedure, behind silence, you forget that somewhere, someone's watching, and writing it all down. They filed me away. I filed a case. They didn't escort her out in handcuffs. That's not how it works when power wears a suit. But make no mistake, she was removed, quietly, cleanly, a brief internal memo, no press release. "Reassigned pending administrative review," it said. Translation: her badge was deactivated, her office boxed up, her emails rerouted to oversight. And the courtroom, it moved on. But not before the judge issued a final ruling. All submitted evidence verified and admitted, witness protections upheld, full Federal Ethics Committee notified. I was thanked formally, but it didn't feel like closure. Not yet. Because the system doesn't break in one place. It fractures in corners, under fluorescent lights, and beneath passwords no one double-checks. It breaks when people believe they're too small to be noticed or too replaceable to matter. That was the lie I had lived under. Until I fought back with documents, not outrage. With timestamps instead of tantrums. I didn't burn the building down. I lit up one room and let the rest see the smoke. 2 weeks later, I received a letter, not from the court, not from the media, from a woman I'd never met. She'd read the hearing transcripts. She was one of the removed, a name crossed off, a voice boxed away because it didn't serve the narrative. "I saw your name," she wrote, "and I remembered mine." That was it. That's when I realized this wasn't about testimony anymore. This was about precedent, because now there's a trail, signed, logged, admitted. Someone else will walk it. Someone else will use Clause 9C. Someone else will know that even when they whisper, "You're not on the witness list," it doesn't mean you don't belong. It means they're afraid of what happens when you do. They built the list to keep people out. I turned it into a door and left it open behind me. 2 months later, I walked past the courthouse, not to enter, not to testify, not to deliver evidence, just to walk. The bench outside courtroom 3B had a new plaque. The marble floor had been polished since I last stood on it. The security guard at the front desk nodded at me, not because he knew my name, but because he remembered the day everything changed. That's how justice works sometimes. Quietly, without applause. But if you listen closely, you can hear the shift. The prosecutor never returned. According to public records, she withdrew from the bar, voluntarily. No formal charges, but she'll never practice again. Her digital fingerprint has been scrubbed from the state's official legal directories. But I still have the contract, framed, folded, dated, signed by the state attorney, countersigned by the U.S. attorney, and notarized with the clause that changed everything. Clause 9C. It didn't make me powerful. It made me unerasable. And that's more dangerous to people like her than any headline. I now work in oversight, not because I needed the title, but because I'd already done the job without one. I review witness procedures. I read between digital lines. I train others how to document everything, even what feels insignificant, especially what feels insignificant, because corruption rarely starts with a bang. It starts with a small deletion, a name removed, a file misplaced, a spreadsheet cleaned up for clarity. And unless someone is watching, it becomes culture. But not anymore. Not while I'm watching. Sometimes justice isn't about punishment. It's about prevention, about teaching systems to flinch when they see the paperwork lining up against them. Because now they know, if they try to erase another name, it might be mine again. You don't need permission to show up with the truth, just a contract and the courage to carry it in your pocket.